Welcome to FFRF's Ask an Atheist. I'm Liz Cavell, Associate Counsel here at the Freedom from Religion Foundation. I am in our studio in Madison, Wisconsin. And joining me via Skype is Patrick Elliott, our Senior Counsel. Hi, Patrick.
Hi, happy to join you today.
So today, Patrick and I are discussing our reactions to oral arguments that the Supreme Court just heard this morning. Not 2 hours ago, they ended. So these are our very hot takes on Dobbs versus Jackson Women's Health. That is the case that has Roe versus Wade in the crosshairs of the Supreme Court.
And so, we're going to be giving our fresh takes. Liz and I just listened to this today. So there's going to be some media clips that we'll share and try to dissect what that might mean for how the court may rule in this case next year.
That's right. And as always, you can join in our conversation by making comments or asking questions right below in the Facebook comments, or you can email askanatheist@ffrf.org. So we're just going to jump right in. First, Patrick, could you just give some background to anyone watching on the Dobbs case? What is this lawsuit? How did it get to the Supreme Court?
Yeah, and as people may be familiar, in the news, there's been a lot of news about these abortion restrictions that states have been passing. In 2018, Mississippi passed a 15-week abortion ban, which impacted the only abortion clinic in the state of Mississippi, which was Jackson's Women's Health Organization. They challenged the law the day that it went into effect. And because of the strong precedent on this, both Roe versus Wade and Planned Parenthood versus Casey, they secured an injunction, a preliminary injunction. That was upheld at the very conservative Fifth Circuit Court of Appeals. The state of Mississippi has appealed that to the Supreme Court. And so that's kind of where we got today. But, some of the interesting issues are the court, when somebody presents a case, presents different issues. And so the question that the court will be answering is whether all pre-viability abortion bans are unconstitutional.
Right.
So that kind of is how the arguments were shaped today, I think.
That's right. So just really quickly before we jump into the arguments this morning, all you really need to know, layperson or lawyer, going into this is what you already probably know, because the law has been settled for the past 50 years, which is when Roe was decided, is that the line for where states can ban abortion has been set at viability, which hasn't really changed over time. It's more or less 24 weeks of pregnancy. That is the time at which a fetus can survive outside of a pregnant person's body. And so that has been a kind of a logical line that courts have used to draw for when state interests can come into the equation after that point. The state interest being the interest in fetal life versus leaving the decision completely to the pregnant person and their physician, which before viability has always belonged to the pregnant person. So that has been the law of the land for the past 50 years. That's why the lower courts struck down the 15-week ban in Mississippi. And the fact that the Supreme Court has agreed to hear this question of whether viability is the line at which bans should be unconstitutional is obviously a sign that the court is now open to completely reconsidering that rule.
Right. And the court, not too long ago, had taken other abortion cases where the courts of appeals were going rogue and not abiding by precedent. So the courts would call that, stare decisis, basically following the prior cases. Whole Women's Health Organization being one of those. One major difference was the makeup of the court. Justice Kennedy was a justice on the court at the time. That's all changed with the court taking this case. And so I think that's part of, maybe the theme or the fear that will come out of this case is what is this court going to do, which has new justices, including Justice Barrett, Justice Kavanaugh. How is the court going to treat that? And I think that kind of came out in some of the arguments today.
That's right. So right away, the first person to argue was the Mississippi AG on behalf of the state of Mississippi that's trying to defend their ban on abortions going forward from 15 weeks. So right out of the gate, it was striking because he was arguing very explicitly and very, I thought, sort of provocatively for the court to openly overturn Roe versus Wade and Casey, which is a case that followed Roe, and kind of expounded on its rules. What did you think about the opening, Patrick?
Yeah, I mean, the first thing, so I'm going off of memory because, people will have a transcript when that eventually comes out. It was kind of shocking, just as a lawyer, the metaphors being used by the Solicitor General for Mississippi were kind of using violent terminology, and maybe, that was planned because the opening statements are planned and practiced by the attorneys, and then they know they're going to get lobbed with questions, so they don't really know how to prepare. So this was a very calculated statements by Mississippi, really trying to use kind of a language of violence, and then also going head at trying to get this court to overturn Roe and to overturn Casey. That's a bit different than some of the briefing that had previously taken place in this case. The parties kind of argue about, well, maybe a 15-week ban, wouldn't be unconstitutional. Here, they're just going for it. They're going for the full undoing all of that work, which has been, 50 years of precedent in the U.S. that states have abided by.
Right. So because of that, I think right away the oral arguments kind of took a lot of the justices took a focus on just whether or not and why they should or shouldn't overturn what is a very settled precedent of the court. And the concept of stare decisis is the fancy Latin way of saying courts, especially the Supreme Court, when they rule, it's the law of the land. And all the lower courts and the Supreme Court itself is supposed to follow what it has done before. And they've developed a whole kind of analysis for when it's appropriate to completely overrule itself. And so a lot of the back and forth in the arguments focused on why is that the situation here.
Right. And I think, and we have a clip we'll play in a moment where Justice Sotomayor kind of gets at this issue, which is this kind of goes to legitimacy of the court. If every case was brought brand new and the court would just decide however it wanted, we really don't have a justice system, or at least the court wouldn't be viewed as legitimate in the eyes of the public if decisions come out one way and then they come out the other way. And so there's a good reason for that legal principle, regardless of whether we all agree with maybe the prior case law. Certainly on the Establishment Clause, we have a lot of case law that I'd like to see overturned, but we kind of recognize that that's a framework we have to work with. And so there was kind of an upfront in the early arguments presented to the Mississippi Solicitor General from Justice Sotomayor, kind of questions about how the court should go about that and whether it's illegitimate, really, if the court were to just kind of undo this line of cases.
Yeah, let's listen to that clip because Justice Sotomayor really put it kind of right out front.
What hasn't been at issue in the last 30 years is the line that Casey drew of viability. There has been some difference of opinion with respect to undue burden, but the right of a woman to choose, the right to control her own body, has been clearly set for since Casey and never challenged. You want us to reject that line of viability and adopt something different. 15 justices over 50 years have, or I should say 30 since Casey, have reaffirmed that basic viability line. 4 have said no, 2 of them members of this court, but 15 justices have said yes, of varying political backgrounds. Now, the sponsors of this bill, the House bill in Mississippi, said we're doing it because we have new justices. The newest ban that Mississippi has put in place, the 6-week ban, the Senate sponsor said, we're doing it because we have new justices on the Supreme Court. Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts?
I love that because it really just dragged out into the daylight, and gets at the heart of what's really going on in the states when it comes to anti-abortion activism. Is conservatives took over the Supreme Court, and that is the reason why these conservative states, legislators like those in Mississippi, are taking action now to restrict abortion rights, knowing that they can win because now the makeup of the court has changed the calculus.
Yeah, and Justice Sotomayor referenced this, and I didn't really give this in the intro, but while this 15-week ban was enjoined by the courts, Mississippi then a few months later enacted an even harsher ban, a 6-week ban, similar to Texas and what some other states have done. So what she's quoting from is kind of the brazenness, the idea that the court's on our side, therefore we can kind of rule lawlessly, without regard to what the court has previously ruled on as a matter of somebody's constitutional rights and the real world impacts of that. And I think, and maybe I read too many lawyers on Twitter, but people were reacting to that stench remark because I think Justice Sotomayor, who's my favorite justice, is commenting to the public, maybe to the other justices. I don't think that was really a question that any lawyer in front of her that the Solicitor General could answer, right? Like she's saying our legitimacy is in question if we're going to go down this road of overturning Roe versus Wade.
Right. And because legislators are acting explicitly with political motivations in front of the court. They know that the court has become compromised politically, and so they are explicitly saying in the legislative history of these bills, we can do this now because the court is on our side. And Justice Sotomayor is, I think, rightly kind of chastening the other members of the court who are being targeted by these legislators. So that issue, the legitimacy of the court, in terms of whether or not it's going to follow its own precedent on Roe and Casey, became an issue for a number of reasons. And legitimacy was one of them. And several justices expressed some angst about what it says about the legitimacy of the court if they suddenly overturn Roe. I'm trying to think, Patrick, and I'm just remembering back, we just listened to these arguments. Like, what were some of the other kind of ways in which stare decisis, following precedent, kind of featured in the arguments? I mean, legitimacy was a big one. I think reliance was a really big one too. But how else did you kind of hear that?
It was a major theme, and it came up in a number of different ways. One of the frustrating parts, I think, for us to listen to it was hearing kind of the cases that the Supreme Court did overrule its prior precedent. So like Brown versus Board of Education being referenced by the conservative justices as, oh, this is something we must do. We must overturn our precedent if it's incorrect. Not really recognizing, those are cases where the government was being restricted. And in fact, constitutional rights were being expanded or protected rather than what's going on here is really taking away rights that the court had previously, ruled in favor of, being one problem. So there was a theme, I would say, of citing to cases about race, citing to cases like Obergefell about gay marriage, Lawrence versus Texas, kind of a, privacy and whether, somebody could be, prosecuted for engaging in homosexual sex, whether that could be prosecuted. So there's kind of these references to these cases of, oh, isn't it great that the Supreme Court overturned its prior precedent with some of these decisions. So it was frustrating, I think, to hear that you hear some of the conservative justices citing the cases that I don't know that they would rule that way. They certainly didn't rule that way. Some of them on Obergefell. So that's one of the problems, I think, is that kind of treating this as this is kind of their duty to overturn Roe in some sense.
Right.
Is one of the issues.
Right. Kavanaugh picked up on that. Some of the other conservative justices, kind of pontificated about, well, what Patrick's talking about is what we heard a lot of this morning from conservative judges on the court was, isn't this kind of like Brown v. Board of Education? In other words, the Supreme Court is supposed to overturn itself when its decisions were patently wrong when they were decided. And analogizing Roe and Casey and its progeny with Brown versus Board of Education and some of these other, Obergefell and some of these other cases that Patrick's talking about. And it's very obnoxious because it's literally just like gun cover for a totally not analogous situation, because what's going to happen in this situation is a contraction of individual rights and an expansion of government power to curtail rights. So we did hear a lot of that sort of cover and kind of confusion of when and why the court has historically overturned itself. Another thing that some of the what are called the more liberal block of justices kind of drew out, and that I think was noted by some of the, there is no middle, but by Roberts and some of the other justices as well, is that this has been 50 years of unbroken precedent. And as a society, we have come to understand that a woman's right to I won't say full choice, but a woman's right to an abortion before viability is protected in our under our kind of constitutional framework of personal liberty. And pulling that rug out from our entire society is a really important factor to consider when you're thinking about completely overturning this precedent, this long-standing precedent. So one of the clips that I pulled, and tell me if you have one too, Patrick, was of Justice Kagan sort of talking about like nothing has changed except now there is massive reliance on this, and you're asking us to just kind of flip a switch. So we can listen to that Justice Kagan clip, and this is her kind of directing this point and this problem to the Mississippi AG.
That's what strikes me when I look at this case is that, not much has changed since Roe and Casey. That people think it's right or wrong based on the things that they have always thought it was right and wrong for. So the rationale behind those cases has something to do with the autonomy and the freedom and the dignity of women to pursue their lives as they wish, to protect their bodily integrity, to make the decisions that are most fundamental to the course of their lives. And always in those cases, there was an understanding that there were important interests on the other side in protecting life or protecting the potential for life, whether people saw it one way or the other way, and that there was a difficult question here and a balance to be made. And it strikes me that some people think those decisions made the right balance and some people thought they made the wrong balance. But in the end, we are in the same exact place as we were then, except that we're not, because there's been 50 years of water under the bridge, 50 years of decisions saying that this is part of our law, that this is part of the fabric of women's existence in this country, and that places us in an entirely different situation than if you had come in 50 years ago and made the same arguments.
So that's Justice Kagan sort of pointing out what I thought was really important, and that was sort of getting muddled this morning, which is there's actually not anything new for the court to analyze in the record or in the briefing. And tell me if you think that's unfair, Patrick, but it really is just a pure situation of the membership of the court has changed. And now the state of Mississippi is asking the court to just say Roe was wrong. Roe and Casey were wrong. Viability is just some arbitrary line, and we as the court should have nothing to do with it. And the states are free to restrict and ban abortion. And not much has really changed. So there's not a lot of kind of factual or scientific things changing that are affecting, where the line should reasonably be drawn. It's really just everything is pretty much the same. The interests to be balanced are the same as they were in Roe and Casey. And the only thing that's changed is that we as a society have been living under this framework for generations. And that's really important in terms of what's going to happen when this court overturns Roe.
Yeah, and I think maybe this was kind of implicit in Justice Kagan's question, but some of that analysis as to has enough changed that we would revisit Roe, that was already done in Casey, in the 1990s. Right. So the court's already gone through these considerations. And so I guess what they're kind of talking at this, the judges are talking or the justices are talking to each other. And so it's kind of hard to follow. We're trying to dissect that. But one of the conversations they're having is it's not enough to just be the case was decided wrong. It has to be egregious today because of some of these other circumstances, such that, there's real world impacts that are negatively impacting people, or people are, I think on the reverse side, there's reliance upon these decisions and the way that our legal institutions are shaped or the actions of people. So to sum it up, Mississippi hasn't carried any burden of showing why these cases should be overturned, even if they say, hey, these are wrongly decided under some kind of constitutional principles. They still haven't hit that next step of it's egregious and we need to overturn them. And that's, I think, what you're hearing from some of the more moderate justices are maybe discussing. I don't know if they're actually thinking that, but definitely the liberal justices are pointing this out, which is if we do this, this could apply to all of our other cases on constitutional issues,
right.
Which is true.
Right. And of course, we did hear that with several justices, and I can't remember, Patrick, if any of our clips touch on this, but several of the justices brought up the fact that, there are a lot of controversial opinions that come out of this court that could easily be just completely flipped and overturned based on the makeup of the court. And how do we distinguish between this and those? And the answer is that's already been done, because the court does have cases, and they were kind of quoted at length by Justice Breyer, too much length maybe, and others that express how the court is going to go about analyzing when to overturn prior precedents. There are factors, not just, we think the current court thinks that the old case was wrongly decided. There are other factors that are supposed to be in place. And so there was a lot of talk about how, kind of jettisoning or ignoring that analysis to overturn Roe is really going to upend the apple cart for a lot of these other cases that are equally controversial.
Right. And I don't know if you want to, on the topic of, I guess, being controversial, we filed a brief in this case, Liz, which, you authored, and I don't know if you want to share a little bit about that brief, because it kind of, in some sense, factored in today, maybe not intentionally what the Justice Sotomayor intended, but, we filed something, and I think it was helpful on this issue. And I think I've even seen some previews of some of the questions we're getting asked is kind of, why do we care? Why does, the Freedom from Religion Foundation care? So I don't know if you want to share a little bit about our brief and how that led into the argument today.
Yeah, definitely. So we filed an amicus brief in this case, even though we're not parties, and that is just a friend of the court brief that many individuals and organizations file in big cases that are going to affect society as a whole. And our position in our brief, which is kind of unfortunately unique to our view, which we think should feature more in the way that courts have analyzed abortion restrictions and laws, we argued and tried to kind of point out that the court shouldn't ignore the fact that the only basis for legislating prior to viability in these early weeks. And you can hear it in the argument of the Mississippi AG. They talked about, this is a law where the state is allowing individuals to terminate a human life, or like human life and human beings, we're allowed to protect them in other contexts, but not before viability. And the whole point of our brief is that when legislatures are passing those laws and using definitions of human being that include any embryo or fetus after the point of conception, that those legislators are making a religious value judgment, and that is not a proper basis for a secular law, and that the courts will have to reckon with that if they throw out the viability line, which is objective and has a secular basis. It's not perfect, but it balances interests in a way that is not based on a religious value judgment. And so we tried to make that point in our brief, and it's part of the reason why we are invested in this issue as an organization. Part of that has to do with FFRF's heritage. It was founded by Ann Nicol Gaylor in the 70s, partially as a response to her work as a abortion rights activist and finding the power of the organized religious opposition to reproductive rights, and how essential it was to stop that from influencing what our secular laws and policies are. Also, our membership, 98.8% of our membership view the legal right to abortion as a really important secular right. So our memberships, almost all of our membership supports this issue and views it as an important secular issue. So we advocate for reproductive freedom, but more importantly, we advocate for laws around this issue that are not based on religious conclusions about when life begins, because, of course, that's an Establishment Clause question, although the courts have not analyzed abortion laws in that way over the decades. The issue is still there. And I think Pat and I were both surprised and pleased to hear Justice Sotomayor actually kind of bring that point up to the attention of the Attorney General in Mississippi. So if we have that clip, let's roll that.
How is your interest anything but a religious view? The issue of when life begins has been hotly debated by philosophers since the beginning of time. It's still debated in religions. So when you say this is the only right that takes away from the state the ability to protect a life, that's a religious view, isn't it? Because it assumes that a fetus is life at when? You're not drawing when do you suggest we begin that life?
Your Honor, aside from...
I'm putting it aside from religion.
I'll try to, I think there might be more than one question, and I'll do my very best, Justice Sotomayor. I think this court in Gonzalez pretty clearly recognized that before viability, we are talking with unborn life with a human organism.
Yeah, so that just made my day, because even though this case is not going to go the way that I prefer, I think it's so important that somebody on the court is actually kind of pointing out the things that we ignore in this debate. And that's a big one, which is and if you have a chance to listen to some of the arguments, it's all recorded and online. That's a great place to really give a longer listen, because Justice Sotomayor continues to push back on the idea that there is any kind of real scientific or secular basis for drawing conclusions about when life begins for the purpose of making legal conclusions about when the state has an overarching, a prevailing interest in protecting that human being. You have to define human being and when life begins as a legal matter, and that needs to be based on something other than individual legislators' religious views. And so I just was like, I don't know that appeared in the briefing, in the primary briefing. She didn't reference our brief, but I'm so glad that we made that point, because I think that that's something that has been long ignored by the courts when it comes to abortion restrictions, to the point where, parties don't argue it anymore. But I think it creates problems for the courts going forward that are going to have to, without Roe and without the viability rule, are going to have to analyze these laws that really don't have a secular basis or a secular purpose in how they're defining life and who's protected and what their interests are.
Right, and I think that last point is kind of, for the brief that you wrote or that FFRF submitted, is kind of why this relates to the case. Is when the government is claiming it's passing these laws, we know a lot of the times it's lying about its reasons. For instance, on abortion restrictions, there have been a number of states who've said that doctors needed admitting privileges at local hospitals in order to perform abortions, and they claimed that was for the women's health, when in reality it was because they have a religious belief. They want to eliminate or restrict as many abortions as possible. And so that all comes back to, if you get rid of the pre-viability standard from Casey and from basically from Casey, what is the standard that is going to be applied? Because we know, FFRF especially knows that the government will lie about what it's doing. Like, they don't come out and say, I have a religious belief, I need everybody else to follow it. They say, we think, all abortion doctors have to have admitting privileges at local hospitals. And on its face, it appears that they're actually doing something for the benefit of women. But in reality, they have a religious view that they want to stop all or most abortions. So that's, I think, why this kind of does tie into some of the things that we are experts on in terms of, the government really not being truthful in why it's passing certain laws. That happens with religious laws all the time. And I think it's kind of come up here. And I don't know if that's what Justice Sotomayor was getting at, but I think she's kind of tapping into people have different religious views on this, and kind of what's the state's position on that. And the state, I don't know that there's any good answer he possibly could give, but the language used by the Solicitor General is definitely right in line with what the right to life groups and all the anti-abortion groups, would say. The language that they're using is exactly as the religious groups would do. And this is a state. This is a state's basically making its arguments before the Supreme Court.
Absolutely. He consistently was using the language and the really provocative anti-abortion, kind of vocabulary of we're talking about a fetus before 15 weeks. So for first trimester embryo and fetus, that, he's using the language of this is a human being, this is a human life, this is the taking of a human life, in terms of the state's interest in preventing that. And that's what Justice Sotomayor was kind of dragging out. And I think based on the way that the AG responded, Patrick, I kind of got the impression that he was really surprised to have that religious point, to have to address that religious point in terms of the state's interest being anything other than a religious view. Because what the question she's asking is, please tell me how a state will define when life begins, but early in pregnancy without reference to some sort of religious viewpoint. And how should courts do that? And so that's kind of been our, we've been beating that drum in these abortion cases for years. That has not been the primary feature of court analysis of them. But I think it's really important, especially once the actual secular standard of viability is thrown out.
And, one of the other themes that I noticed, and I think you probably picked up on this too, is there's this discussion by, again, some of the conservative justices about like neutrality of the courts not being pro-life or pro-choice or something, and that definitely the state of Mississippi pointing out, saying, oh, we need to leave it to the people, meaning they want legislators to be able to enact restrictions on somebody's constitutional rights. I thought that was just very curious language, because we don't talk about other rights in that way. If it's a free speech restriction or Fourth Amendment, a search and seizure restriction. Certainly, we don't talk about neutrality of the courts in that way. And so we do have another clip, and this is, I think Justice Kavanaugh kind of uses a little bit of that language or that theme, and we'd like to play that for you.
And that they are saying here, I think, that we should return to a position of neutrality on that contentious social issue rather than continuing to pick sides on that issue. So I think that's, at a big picture level, their argument. I want to give you a chance to respond to that.
Yes, a few points, if I may, Your Honor. First, of course, those very same arguments were made in Casey, and the court rejected them, saying that this philosophical disagreements can't be resolved in a way that a woman has no choice in the matter. And second, I don't think it would be a neutral position. The Constitution provides a guarantee of liberty. The court has interpreted that liberty to include the ability to make decisions related to childbearing, marriage, and family. Women have an equal right to liberty under the Constitution, Your Honor, and if they're not able to make this decision, if states can take control of women's bodies and force them to endure months of pregnancy and childbirth, then they will never have equal status under the Constitution.
Yes, so that was a great answer by the attorney for Center for Reproductive Rights. Sorry, they are the ones challenging the law. And that was Kavanaugh. And a lot of his questioning was kind of, Pat, in this tone of, oh, shucks, this is so hard. This is just such a hard issue. There's there's important interests on both sides. And that's what makes it so hard. And isn't how hard it is really the reason why the court should really just be, zealously neutral on it, because, we don't want to jump in and take sides on this divisive issue. And so I thought that answer was really the perfect kind of retort, because it really puts back into the frame, this is an issue where the court has already determined there's a fundamental right being infringed. You can't forget the actual individuals who are having a liberty taken away from them if you withdraw and decide you should maintain a neutral position on abortion. There's a liberty interest at stake. This is not just, you're not being asked to referee something, a fight between your kids. That there's the constitutional fundamental liberty that the court has decided exists, and you're being asked to take it away from millions of Americans.
Yeah, and I mean, maybe this argument to me, and I think you and I, when we were chatting during the argument, it almost seemed that some of the justices were going back to almost elementary level or middle school level arguments about abortion in terms of some of the philosophy issues. Or here, this is the whole point of courts. We have a judicial system. They're not neutral and saying, well, you both make good points. It's saying, hey, they're violating our rights, whatever the constitutional issues are. So it's kind of bizarre to hear, somebody at such a high level and with that education to be saying, well, we're just neutral and we're just going to let states do whatever we want. We don't let states do whatever they want on a number of other things. And I think Justice Sotomayor pointed out at one point, well, wouldn't this all apply to the Second Amendment and all the other amendments if we're just going to kind of be on the sidelines for these issues or overturn prior precedent? So I think just overall an air of frustration, I think at the level of some of the discussion from some of the justices, and this being one of them, that somehow they're acting neutral. If they're about to force women to have a baby, that they're acting neutral. That's just that's a fiction that
Right.
I'm never going to buy into.
Right. It was just this kind of a lot of overly playing dumb about what they're being asked to do and how significant it is. That the federal courts can just withdraw from the issue and leave it to the states. And it's fine. Like, don't worry. If you live in a liberal state, you probably won't even notice. And if you don't, then it's fine. You know, just very, like, just minimizing what the impacts of this decision will be to a point that was just mind-boggling. And unfortunately, I think all the signaling we heard this morning really broke down along the lines that you would think. You know, conservative justices were kind of making these types of excuses and kind of grabbing on to these points about neutrality and about how it's okay to overturn, you know, these watershed cases. And then, of course, you had the minority kind of trying to push back and keep the importance of the issue in the frame. And so I don't think there were necessarily any surprises. What do you think, Pat?
Yeah, I don't think it's surprising. Again, I'm reading it as, you know, as a lawyer, sometimes we have to defend ourselves if you ever have a conversation with somebody in the public and you have to say, well, why we exist and why there's courts is because people aren't good at resolving their own disputes, right? Like I'm in the corner of our judicial system. I think that's what our duty is, but it's hard to defend this. Like, listening to these arguments, I think it makes me think that, you know, maybe our courts aren't doing the job that they're doing. Maybe our lawyers aren't doing their job they're doing. And they when they talk about these issues, it's very at like an academic level or of the language of courts. But what they're actually doing behind the scenes is, you know, a bunch of religious people got put into the court by the Federalist Society to undo Roe versus Wade. And they're gonna, in doing so, they're gonna act like they're neutral arbiters in discussing it. And so I don't really like buying into their way that they're talking about this case. I think they're coming with their own biases. And I don't want to say that as a lawyer because it's my job to be an officer of the court and to defend what the courts are doing. But sometimes there becomes a point where you're very frustrated, and I don't know that how the court is handling this case in particular is defensible.
I know it is tiresome to like have to feel and be so cynical all the time, but when it comes to this case, I really do think what's going on is exactly what Justice Sotomayor pointed out at the very, you know, top of the arguments, which is the new justices, the new majority, are being targeted by anti-abortion activists who are religiously motivated to make abortion as hard to obtain for as many pregnant people as possible in this country. And so that's what's happening, and that's probably in some way, shape, or form how this decision will come down when we finally hear what the court does, which will probably be next summer.
Yeah, and I've got, that will lead us into some of the questions that we're getting. So Amber Shue asked, do you have any predictions on what the final decision will be? Is there any hope that Roe v. Wade will be saved?
In a word, no. But I think there are probably a few, maybe, you know, 2 or 3 different paths that the court can take. But I think it's important to note, and even some of the justices were kind of blatantly ignoring or playing dumb about this in their questioning, but the question that the court decided to address, the court decides what the question before it is, and that question today was, are abortion bans before viability always unconstitutional? And that tells me that what the court is considering is overturning Casey and thereby Roe by saying, basically, we're not gonna say that there's a blanket rule that states cannot ban abortion before viability, and that's going to make all the states free to do what they want in terms of enacting abortion bans. And a lot of states, including Wisconsin, where I am, have, you know, kind of either trigger laws or old abortion bans still on the books that their conservative legislatures are just kind of waiting to go into effect after a decision like that is made. They may not say Roe is hereby overturned, but they could still decide that, you know what, this 15-week ban is no longer going to be prohibited by our case law because whatever, viability is not, it was wrong when it's not in the Constitution or something like that. What do you think, Pat?
Yeah, no, I think you're right that the answer to the question they've granted certiorari on is going to be not all pre-viability bans are unconstitutional, and that leaves us back at square one, which is like, what is unconstitutional? What's the test? What are courts supposed to do? What are states supposed to do? And I think that's a very tricky thing for this Supreme Court to handle. So it's hard to predict, but I think the signs are there that this court wanted to be activist to take this case to overturn that precedent. So we'll see, how they go about that. And we do have two more questions here, and I'd like to ask you.
Yeah.
This is kind of coming up now with all the vaccine requirements. Jenny Kosser asks, for some people, it seems to be a whole my body, my choice argument for not, taking vaccines or wearing masks. Why doesn't that argument extend to abortion rights?
Why doesn't it? Did you notice, Patrick, in the arguments that Justice Amy Coney Barrett had to get in there kind of an analogy towards vaccines in the framing of one of her questions? And I think this is something that is definitely on the minds of conservative justices, but not the way that this person asking this question would hope, in that they view that as like a really important gotcha for why states should be allowed to ban abortions, because it's just like requiring people to get vaccines. It's requiring people to give up bodily autonomy for some state interest. And so I get the impression that conservative justices and lawyers view that as like a really strong analogy in their, playbook. Yeah, I don't know. Because it says to people of a certain, because now it's politically signaled. So like, if I'm into vaccines and masks, you think I'm probably liberal. So therefore, if I'm liberal, I probably am into abortion. So it's a big gotcha moment to be like, well, why don't you feel the way about abortion that you do about vaccines? And of course, it's hardly analogous. I say this as a 27-week pregnant woman. It is a very different experience than when I got my vaccine. But, it's all academic at that level.
Yeah, no, certainly. I mean, we're used to seeing the people being very hypocritical on issues. We filed a brief also in a death penalty case, arguing in favor that the state couldn't execute the person who was on death row, and the court temporarily blocked his execution because he claims he has religious rights to have a minister lay hands on him while he's being executed and to have vocal prayer. So, the same people arguing, obviously, on that issue have hypocritical opinions. I think FFRF certainly is consistent in our arguments in these cases. And I do have a final question, and I guess this kind of also relates to kind of the hypocrites that are out there. This is from Casey Heidel. Do any of the people who hope to overturn Roe versus Wade have any plans for legislation that will push comprehensive sex education or affordable birth control, or something to support the innumerable women who will be financially unable to support children from these unwanted pregnancies?
Yep. Yeah, I mean, I think that's the impact that was like woefully lacking from oral arguments. I do think there was a really frustrating strain of oral arguments from conservative justices that we didn't get to talk to today that had to do with basically women have access to birth control and adoption, so why do we need abortion was kind of the strain. Although I do think there so much was ignored in terms of what we lack in terms or in reproductive health infrastructure to allow for this, total watershed in what we're about to do with our abortion access. What do you think, Pat?
Yeah, I mean, it's just just the overall frustration. I mean, it also came up the idea of, and I'm going to call them like safe harbor laws, where some states, which I believe Mississippi has, where a parent of a newborn could drop off the baby at certain locations within, let's say, 48 hours, or I don't know the requirements, but that was brought up, and I think that that's really a distraction from the overall issue of, are you going to force somebody to carry and deliver a baby? Right. And the fundamental issues that have already kind of, basically, I think we were rehashing arguments and ground already made on this issue. And so that question, I think, is getting at the people who claim to care about other people really aren't doing a whole lot to care for the children once they're born, which I agree with. And I think a lot of people think about that. We're both parents of young kids. It's a burden. It's very difficult to have to raise children and the costs and burdens on that. And there were a number of briefs raising the economic and the financial issues for people who have low income. So it is an issue that was discussed before the court, but again, not in probably the framework that you or I would want to talk about.
Right. And just a total lack of really grappling with for all the talk about stare decisis and we're overturning this and what does that mean and what should we consider? There was just a real lack of grappling with the real world impact of this. And I think just a real head in the sand approach with some of these conservative justices to how many of us deal with and live in this reality where abortion access before viability is a protected liberty. It was pointed out by several of the lawyers that 1 in 4 women have had an abortion in this country. So we're not talking about something on the fringe and you could really fill the gaps with adoption and birth control. We're talking about this will be a completely earth-shattering blow to our society. So it's alarming, but I'm always with the dark final thoughts. Patrick, anything else to wrap up?
No. Thank you for filing a brief on behalf of us in this case. I think we were well represented in this case.
Yeah, I think so too. And I was glad it came up today. That was something. Well, that's our show for today. And thanks so much for joining us, Patrick, and those of you watching as we kind of give our live reactions to the arguments that just happened. You'll probably hear more about this from us in the coming weeks and months, but thanks for joining us today. And this week on FFRF's broadcast program, Free Thought Matters, Annie Laurie Gaylor and Dan Barker will be talking to Michael Nugent. He is the co-founder of Atheist Ireland. Here, Michael describes the amazing pace of progressive change in Ireland over the last decade.
The same year, we then had another referendum to remove the offence of blasphemy from the Constitution. And so that's 3 referendums in a row: marriage equality, abortion, and blasphemy. And the significance of those 3 referendums is that all 3 of them, we won them by about a 2-to-1 majority. So there's a pattern right now. Yes. It's now clear that there's a consistent majority in favour of liberal, compassionate, human rights-based approaches to these issues that were once controlled by the Catholic Church.
And you can watch Free Thought Matters on TV stations around the U.S. on Sundays or on FFRF's YouTube and Facebook channels. Also this week on Free Thought Radio, Dan and Annie Laurie will speak to Willie O. Cartwright, the author of the book Saved to Sane, My Journey Away from Christianity. You can find out where to hear Free Thought Radio at ffrf.org/radio. Thank you for watching FFRF's Ask an Atheist. Thank you, Patrick. We'll be back next Wednesday at noon here on Facebook Live.